I have been sitting on this bench for 40 years, and you think you have seen every kind of arrogance that walks through those doors. You have seen wealthy people who think money can buy the law. You have seen thugs who think aggression can intimidate justice. But every once in a while a different kind of arrogance appears, a more dangerous kind wrapped in expensive suits and prestigious university degrees. It is the arrogance of intellect, or rather the dangerous delusion that because you are smarter or better educated than everyone else, the rules of society simply do not apply to you. Let me tell you about the morning that Nathaniel Crosswell IV walked into my courtroom, 23 years old, a senior at Harvard Law School, the son of a federal appeals court judge, and the heir to one of the oldest legal families in New England. He drove a black Porsche 911, and he was here for a reason that would make anyone with a conscience shudder. Doing 80 miles per hour in a construction zone with a posted limit of 25, not 80 on an empty highway. He was moving like a missile through a zone where men and women were actively repairing the road, separated from traffic by nothing more than a few plastic cones. The citation on my desk was clear: reckless operation, endangering lives, and failure to obey a police signal. But Nathaniel Crosswell didn't just accept the ticket and show remorse. Oh no. He did something that only those who believe they stand above the law would dare to do. Instead of paying the fine or hiring a lawyer, he decided to represent himself. He sent the court a 30-page motion before his trial date, citing the Constitution and case law from the 19th century, demanding the case be dismissed due to officer incompetence and violation of the right to travel. He treated this courtroom not as a place of accountability, but as a stage to practice his litigation skills, a real-world exercise for his future career. He treated the lives of those road workers as nothing more than a hypothetical scenario in a law textbook. That morning, Nathaniel walked into my courtroom as if he owned the building 9 a.m. sharp. He appeared in a bespoke suit, wearing the crimson tie characteristic of Harvard, carrying a leather briefcase stuffed with thick law books. He didn't look at anyone. He didn't look at the officer who stopped him. He didn't look at the regular citizens waiting for their turn. He walked straight to the defense table, opened his briefcase, and began arranging his documents with a cold, detached calm. I looked down at him from the bench, a young, intelligent face, but eyes that radiated quiet contempt. He didn't look at me like a judge to be respected, but as an opponent to be defeated. In his mind, this was just an intellectual game, and he had already calculated his victory. "Nathaniel Andrew Crosswell IV," the clerk called out. He stood up unhurried and adjusted his suit button. "Present, Your Honor." His voice rang out, crisp and articulate, clearly practiced in the style of top-tier litigators. "And before we proceed, I wish to note for the record that I am representing myself pro se. I believe the truth and the law are absolutely on my side." I looked down at the file. 80 in a 25 zone. "Mr. Crosswell, you are accused of driving 80 miles per hour in an active construction zone. How do you plead? Guilty or not guilty?" Nathaniel smiled, a slight smirk playing on his lips. "Your Honor, the concept of guilt here is a semantic confusion. I do not deny that my vehicle was traveling at that velocity. However, I deny the legitimacy of the stop and the officer's authority in that specific context. Therefore, I plead not guilty." I have seen many people try to find loopholes, but the way he spoke, as if he were lecturing me on the law, sucked the air right out of the room. "You are saying that driving 80-mile-per-hour between workers who are fixing the road is legal?" I asked, trying to keep my voice calm. "I am saying that," Nathaniel interrupted. "A fatal mistake in my courtroom, that in urgent situations the law allows for exceptions, and I, Your Honor, was in a situation that the law defines as a necessity defense. Furthermore, I have evidence that Officer Martinez failed to follow the proper radar calibration protocols under Section 31(4) of the Rhode Island General Laws." He began flipping through his law books, his finger-tracing lines highlighted in yellow. According to the President in State v. D'Agostino 1982, he started to ramble on, but what caught my attention wasn't his legal knowledge, it was his attitude. He hadn't said a single word about safety. Not a single apology, just statutes, loopholes, and arrogance. He thought that Harvard degree and that pile of book knowledge was a get-out-of-jail-free card. "Pause for a moment, Mr. Crosswell," I raised my hand. "You speak of a necessity defense. Where were you going in such a hurry that makes you think the lives of those construction workers were worth less than your time?" Nathaniel stood up straighter, took a deep breath, and prepared to play the ace he believed would silence me and force an immediate acquittal. Nathaniel adjusted his crimson tie, ensuring the knot was perfectly symmetrical. He looked me in the eye, not with fear, but with the confidence of a poker player holding a royal flush. "Your Honor," he began, his voice lowering to a conspiratorial, serious tone. "The necessity defense applies when a defendant is forced to choose between two evils. In this case, the lesser evil was exceeding the arbitrary speed limit set by the Department of Transportation. The greater evil was a miscarriage of justice.